Second case on this morning's docket. It's case number 106646, State of Kansas v. Kelvin H. Gibson, Jr.
May it please the Court, Jeffrey Leiker for Kelvin Gibson. Chief Justice, I'd like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you, sir. The crux of this case is essentially an admission of guilt, confession that was given by a juvenile under questioning that the defendant now maintains is a little bit questionable questioning. Real quick, Kelvin Gibson was a juvenile that was alleged to commit a murder, and he was brought in for questioning by some detectives, and he was Mirandized, but it wasn't until several hours later that the record was actually made, where they started recording stuff, and there was some media available for that. The detectives then went back 2 days later and tried to clear up some things, some inconsistencies in his statement, but the fact was that he was interviewed once, and then they went back and kind of elaborated on the interview 2 days later, which I think becomes kind of important in a case like this and the arguments that he's making. There was never really any testimony involving his sophistication or knowledge about how these things work, but he was a juvenile, and I think this court has determined previously that when a juvenile is being questioned, there are certain things that need to be taken under consideration. It's not a situation where you can't question a juvenile. A juvenile certainly can be sophisticated enough to deal with the police, but in this circumstance, I think the court needs to look at a few different things, and the trial court was asked to do that, and Mr. Gibson maintains that that's not exactly how things went down.
At the original Jackson v. Deno hearing, was there any evidence or suggestion of what occurred during the 2 hours and 45 minutes of questioning and interrogation prior to the videotape part of his statement being made?
Specifically, Justice, I don't recall. If there was, it would have been just the pre-interview that they do and the Mirandization.
Was there any explanation offered as to why the entire encounter wasn't preserved on videotape, or however it's done there, wasn't documented?
I do not know that there was any explanation offered to the court to consider that why there was that break, and I guess when
We've
the
had
reporter went on.
a case in the past where we questioned this very Wyandotte County, I can't remember if it's sheriffs or police, about that procedure. I just wondered if that came into question in this case.
I don't believe it did, Judge, and I have my concerns about why the reporter might go on a little bit later, but specifically in this particular case, we do know that a few hours went by when there was some sort of a pre-interview going on where the detective was getting some information, and then the reporter went on. And I don't know.
You're really not concerned about what occurred during that period of time? Is it basically what you're saying? You call it a pre-interview.
Right. Well, that's...
Isn't it part of the interrogation, and doesn't it just lend itself to question what occurred there?
Absolutely. Absolutely. And I think, at least as far as the brief's concerned and the arguments have been brought forward to this court, I guess that's just one thing that I think we don't really have a lot of information on. The court, we have no idea if the court considered it at all, because the court really didn't mention anything about it.
Or did you raise it? That's my question. Did you raise it at the time that you could have raised it, questions regarding what occurred during that time period?
No, the trial attorney did not, from my understanding, raise that particular issue at the time of the Jackson v. Deno hearing.
Here's the question I've got. At the end of the Jackson v. Deno hearing, the only evidence that was presented was from the detective. The video recordings weren't even involved in it, as I understand it. But more importantly, at the close of the hearing, the defense counsel said that the statement was voluntary, and said that, take into consideration that the defendant's 17, and take into consideration that that the detective has testified that he was afraid. But defense counsel said the statement was voluntary. And so given that admission, what more do we have to talk about?
Well, there's a number of different factors that we cited in the brief that need to be determined when a juvenile is being questioned, not just his age or the sophistication, but, I guess his level of intoxication. In this case, we actually know, at least from, and it was discussed at the Jackson v. Deno hearing, that the juvenile at some point used marijuana before that. And I guess, for instance, what the judge should know and maybe comment on is, I guess, how do we take that evidence of the intoxication levels itself? When you have like a DUI stop, you have somebody walk the line. It's not necessarily that they can't walk the line. We're not saying that Kelvin couldn't read or listen to the detective read to him the statement that he signed regarding Miranda. The question is, what's his level of impairment there? What is, his judgment is impaired. And so the argument that he's making is that my judgment was impaired here, and I might not have understood it. And I guess another analogy might be, if you're going to enter into a plea that day, and one of the first questions the judge asks you is, okay, is your mind clear? Are you under the influence of any alcohol or drugs that might affect your judgment? If the defendant says, no, I just used marijuana a couple of hours ago, well, you're not given your plea that day. And in this case, the detective testifies that we questioned him once, then we wouldn't question him again 2 days later. So we know that he had the ability to hang off on the interrogation for at least a couple of days and go back and talk to him again when his mind was a little more clear, when he kind of understood. But the detectives got what they needed at that first interview when they knew that he was intoxicated. And that's not really something that the court discussed. And that's maybe the problem.
Counselor, the Jackson v. Deno hearing is not the final order, is it? We've said repeatedly that 6404 requires an objection at trial, which I've said is tantamount to a motion for reconsideration. Mm-hmm. And we've said the rationale for that is that new evidence may come up in the interim. Sure. And so what you're saying is that there was new evidence in between the Jackson v. Deno hearing and the trial, and the defendant attempted to get the additional evidence before the trial court, and the trial court refused to hear the additional evidence.
Yeah, and that kind of goes into the second argument that's presented in the brief, and something that, one of the things I found most troubling about the record itself, and that's there's actually two attempts by not just the trial attorney, but the defendant himself filed a pro se motion to suppress a statement, I think about a month before the trial. And I don't know that the motion to reconsider if I recall correctly, I think the trial was in the summertime. The defense counsel filed for a motion to reconsider perhaps in January, and then the defendant filed his pro se motion to suppress a statement about a month before the actual trial itself. Now, the motion was heard on the morning of trial, and I don't know that the motion to reconsider was ever heard. But the court did briefly address it, and I guess getting to what you were mentioning, it's not uncommon for new evidence to come up and you ask the court to reconsider or take another look at an issue. And in this particular instance, the defendant wanted to testify. He wanted to put on the record some things he thought were important to the court. And specifically, and I know the state, talks about this in their brief a little bit, well, they didn't really object. They didn't ask for findings of fact to be elaborated. But the defense attorney at the time the motion was eventually heard on the morning of trial, says, okay, we would like to make this record. We would like to put on his testimony. And I think that that's pretty much comparative to an objection. Judge, we don't agree with what you're saying. We'd like to make this record so we can move on with the issue itself. And the judge says, no.
At trial, was there a contemporaneous objection to the admission of his statements?
I believe there was.
I guess my question earlier was, why doesn't that encompass all additional evidence that wants to come in? Why shouldn't the defendant be, I don't hear you arguing that the defendant has a right to present the additional evidence at the time that we require a contemporaneous objection.
Well, because this particular issue was a little bit more sensitive. I mean, I could be argued, I suppose, that this trial was won or lost before it even began, because the entire case was really based on the statements that were made by the defendant himself. And so outside of the presence of the jury, when the time comes to file your motion to suppress a statement and talk about these particular types of issues, the defendant wanted to testify. He's not required to testify at trial in front of a jury about these types of things. We had 2 different hearings where he was given the opportunity to. He didn't testify or talk about it the first time around. However, I don't know that precludes him from testifying at a later date, especially after more information comes in. But the court said, no, I'm not going to let you do that. The court specifically said that you had your chance at the Deno hearing to put this evidence on. I'm not going to hear it now. And that was the big problem, I think, that defense counsel and appellate counsel has with what the court did, is that it didn't really even allow for the record. After telling the court, we need this record.
I made some notes here on the young factors. On age, he was 17, correct?
Correct.
And I had length of questioning about 4 hours. Education, 9th grade education. Prior experience with police. He had some infractions for not having automobile insurance, but pretty innocuous prior history. And his mental state was that he was afraid at the time. How much of that, I'm not sure where I got all that, how much of that was before the trial court?
Well, I think really the only thing that was before the trial court might have been the length of the questioning and his age. I don't know that there was anything.
That's really not true, counsel. The detective testified during the Jackson v. Deno hearing about how he had talked to the defendant about the Miranda rights. They read the form. He emphasized the word coercion. He talked about how the defendant was able to read, the way he interacted with the two detectives. I mean, it seems to me that there's a lot from the detective that fills, all those elements. Plus, I get back to my first question. The defense counsel at the Jackson v. Deno hearing says the statement was clearly voluntary. So what's wrong with what the district court did at the Jackson v. Deno hearing?
Right. Okay. Well, I guess to answer the first part of that question, I don't know that I agree that the detective testified to all the factors that were referenced by Justice Johnson. I think that there were some things that were talked about, and specifically, I think you identified them. The one thing that stood out to me was they went over the Miranda rights, and he had a question about, I think it was coercion, and it was explained to him, and that's great. But I don't think all of the factors were presented to the court. I think, a handful of them might have been. The court didn't indicate ever which it considered. It just, said there was no constitutional violation. And I guess with regard to your statement that the defense counsel acknowledged that it may have been voluntary, at some point shortly thereafter, things changed. There were two different motions filed, once by defense counsel and once pro se, saying, this is what was going on. I shouldn't have given this statement. Here are the reasons why. And specifically, the ones that I think defense counsel kind of leaned on and wanted the defendant to testify for the court about a little bit further were exactly what was going on in his mind and the different factors that were just referenced from that case, what his sophistication levels were. But unfortunately, we will never know because, as stated and very clear on the record, defense counsel tried to put it on, tried to make the record, basically told the court, look, we're going to probably appeal this issue if it gets any farther than the trial. And the judge shut her down and said, no, you're not going to put that testimony on. No prejudice was ever shown. There was nothing to say that there was any real inconvenience of allowing a few minutes of testimony. I've seen amazing things happen on the morning of trial, and I understand it's kind of tight there with time, but we're never given any type of information or indication that it was going to be a huge inconvenience or burden or show anybody prejudice to put on that bit of testimony so the court could say, okay, I've heard it, and in light of this new information from you, sir, I'm still going to admit the statement.
We need to look at this case as, from a standard of review standpoint, as abuse of discretion in the consideration of a motion for rehearing or reconsideration. I get back to the fact that you had your chance. Mm-hmm. There isn't any question the defendant had the opportunity to say anything they wanted to say
at the
first Jackson v. Deno hearing,
yes, sir,
and voluntarily chose not to do it. And so now, 4 months later, they get the defense lawyer files a motion, and then I think it was January to June, 4 or 5 months later, that you get the pro se motion. So shouldn't we look at this as whether the trial court abused its discretion in deciding not to reopen the Jackson v. Deno hearing?
Well, I don't think so. I think the review here is automatic. When you're talking about a right to testify in a case, testify in your own defense, tell the judge your own words, I guess if you're at trial, say, and it often comes up where at the beginning of the defense, you might have a hearing outside of the jury, and the judge says to the defendant, "All right, sir, your attorney's told you have the right to testify, and you've chosen not to do that. So you're telling me you're not going to testify," and the defendant acknowledges, "Yes, I'm not going to testify." And then the defense puts on a few witnesses. What if the defendant changed his mind? I don't think the court could say, "No, you know what, you waived a couple of minutes ago, and even though the case is still open, I'm not going to let you testify." In this case, nothing really changed. I mean, you might have more information. Things are going to come in a number of different months. Attitudes change. The case has not been tried. The court has the power at that stage to correct the wrong, and to hear more evidence if it is available. And the defense is saying, "It is available, Judge. Here it is. We want to give it to you." And the judge says, "Nope. Not gonna hear it." "No, ma'am," is exactly, I think, what he said.
According to your brief, the detective testified at the Jackson v. Deno hearing that, in his opinion, the defendant wasn't under the influence, or wasn't intoxicated at least. So I assume that that topic at least was raised. Are you just saying that this new information would impeach his opinion, or what is the evidence that you suggest needed to be added or would have been added?
Well,
And this is in essence asking as a secondary question, is there a sufficient proffer of what that evidence would be for us to know what we're talking about?
well, unfortunately, no. And I guess that kind of goes back to what I believe the state's going to argue here in a second, and that's that there wasn't one given. There wasn't an opportunity for the court to kind of correct its wrong and provide the findings of fact and conclusions of law that we've asked for. But I guess the argument is that to what lengths does the attorney have to beg the court to give the proffer? If it says, "Judge, we would like to put this information on for you so you can hear it in its totality," and the court says, "No, I'm not going to hear that," and that was after the ruling, and this is essentially the attorney's asking the judge to hear the evidence so we can appeal, so you will have the record. And I believe that's made pretty clear, but the court won't allow it. And it's pretty arbitrary, and there's no real explanation why. And that's the real problem that I have here with, and I do understand, why you would question that, because that is an honest question to ask, but I guess the answer is the court wouldn't allow the proffer to be given. The court would not allow the evidence to come in. There was this Deno hearing. There was several months before that, but that doesn't preclude, I don't think, the defendant from making the arguments that he wants to make.
Nothing precluded the defense or the defendant in its pro se motion from putting in those motions whatever they wanted to say. And what they did, and so they say what they say.
Right.
But that's really what you have to go by.
I would agree with that, sure.
Counsel, I'd like to go back to something that I missed earlier when we were talking about the standard of review for this issue. I didn't understand your answer.
Oh, I'm sorry. I think the review on the specific question is de novo review because of his denial for right to testify. I guess, and maybe I misunderstood the question, but I think if we're asking that on that specific issue at the time that the judge denied the defendant the right to testify on his own defense, I mean, I suppose you could use the abuse of discretion as a standard of review, but ultimately it comes down to the defendant wanted to testify on his own defense. He wasn't allowed to do that.
So the standard would either be de novo or abuse of discretion?
I think so.
Which way would you be leaning?
Well, I've leaned, in the brief, I believe I leaned de novo, Judge.
Thank you.
I'm out of time, I see, so.
That's never stopped us before. Do we have any further questions of counsel? Thank you, counsel.
Thank you, Judge.
May it please the Court, the State of Kansas, by Cheryl Lidke, Chief Deputy District Attorney. Our position is not only was he not denied the right to present evidence at the original Deno hearing, but that he also was not denied the right to present evidence at the motion to reconsider or the new motion to suppress. If you read the transcript closely, it's explicitly at the Deno hearing he was asked whether he had any evidence to present, and he said no. At the motion to reconsider / the new motion to suppress, the defense attorney chose to proffer to the court what her arguments would be. At no point did the defendant or the defense attorney say to the court that we're here to present some additional evidence. They argued and proffered that they wanted to be able to say that he was under the influence of marijuana at the time of his first statement. In his pro se motion, he wanted to say he did proffer that he was overly impressed and intimidated by the detective because he was under the influence of marijuana at the time. And essentially, that's all they wanted the court to know at the time of the request for a rehearing on the issue of voluntariness of his statement. So they were not denied the right to present evidence. They chose not to present any evidence. It was only after Judge Burdett said, sorry, I'm denying your motion to reconsider or your new motion to suppress, that then he piped up and said, well, Judge, I want to testify now. I want to present some evidence in the form of my testimony. So I want it to be clear that our position is that he's never been denied a right to present evidence. He just asked that he be allowed to do it at the wrong time.
Wasn't he denied then?
Yes. It was denied at that time because the judge said, I've already given you an opportunity, you didn't avail yourself of that opportunity, and I'm not giving you a second one.
So, to be accurate, he was denied the opportunity, but you're just saying he was denied the opportunity because the request was untimely.
Well, to be accurate, the defense is saying he wasn't given an opportunity at all. And that's patently misleading to this court. He was given an opportunity, and when asked for a second opportunity, that was denied.
You're saying his counsel was given an opportunity to essentially proffer what was new or what the new evidence would be, and when that wasn't forthcoming, that then he was denied.
No, she did make the
testify?
proffer.
Well, but you're saying there was nothing there to the proffer, essentially, that required a hearing?
Well, that was my argument to the court at the time, that both the proffer in the pro se motion and the proffer being made during the hearing added nothing new that had not already been known to the court at the original hearing, and so there was no need to relitigate the issue that had already been litigated at the Deno hearing.
Did it come out in the Deno hearing that he had used marijuana? and
Yes.
said that?
Yes, the state had offered the transcript of the defendant's statement, and in that statement, he clearly indicated that he had used marijuana a few hours before talking with the police. And I addressed with the detective during his testimony whether or not he was able, did he exhibit any characteristics that would lead him to believe that he was still under the influence of any drugs or alcohol, to which he answered no. And he had had extensive dealings with people under the influence. And I think what the judge's finding at that time and later was that perhaps he had been under the influence of marijuana a few hours before, but it wasn't an undue influence. It wasn't impairing his ability to understand what was going on. It didn't affect his ability to freely and voluntarily give a statement at that time.
So is Judge Burdett's ruling, the second ruling, clear that he is saying this additional information that you don't have any new information for me, or that whatever you're saying doesn't make a difference in my previous ruling, or that I just don't want to hear it? Which of those versions or some other is what the ruling was at that hearing?
Well, if you give me a second just to review exactly what his words were. He found specifically that he was not under undue influence from any alcohol or drugs, and that the statement was given voluntarily. And that was after at the hearing on the motion to reconsider and the new motion to suppress. But he had made that same finding, so I don't know if that answers your question or not, because that had been the finding at the original Deno hearing as well.
I want to clarify a misimpression that may have been under. At the original Jackson v. Deno hearing,
Yes.
did you say that the transcript of the interview had been offered at that time, or was
Yes.
it the second time?
the first time.
Because there were some statements, I think, in the defense brief about the recordings not being available, and I took that
Which
to mean that the court didn't have available even what had occurred during the recorded interview, which I,
And that's a little misleading too. They'd always been available. They had never been requested until after the Dino hearing by the defense attorney. The transcripts had been given to them, but the actual recordings themselves, all they have to do is ask us for them, and we provide them the actual recording. And she didn't request those until after the Dino hearing, but she had the transcript prior to that, and that's what was offered during the Dino hearing.
and so did Judge Burdett
Yes, when it was offered,
at
he got it.
At the hearing, okay.
Yes.
First hearing.
At the original Dino hearing. You know, the defense is arguing that Judge Burdett didn't make sufficient findings to enable a meaningful appellate review. I'm asking the court to find that if that is true, and I'm not conceding that it is, that the court's failure to make the proper findings really has to be held against the defendant. He can't complain now. And that's,
Now, I have a little problem with that. The state has the burden to prove that the confession is voluntary.
correct.
Why is it then the defense obligation to get the findings that support the state's burden of proof?
Well, the record speaks for itself. I think that there can still be meaningful appellate review based upon a review of what evidence was provided to the judge. I mean, he obviously had to make some sort of a finding that this was a voluntary and freely given statement, and granting the state's motion at the Dino hearing.
Because of our presumption that the court finds all the facts necessary to support its ruling? Is that why we say he obviously made those determinations?
Well, he said so expressly in this particular case, but I suppose if he hadn't made those, yes. I mean, you could presume that that is true. But in this particular case, we feel like there were sufficient findings, although they were very brief, and that those findings are supported by substantial competent evidence. You know, the court found that there had been no constitutional violations and that the statement was given freely and voluntarily, and then concluded that it's going to be admissible in the state's case in chief. The only evidence presented in this case, supported those findings. Detective Michael testified that the defendant was not under undue influence from drugs or alcohol, that he believed, in his opinion, the statement was given voluntarily, that the defendant had made appropriate answers to the questions that were asked of him, and he responded within the context of what was being talked about. So he acted as if he understood what was being discussed. He did not seem confused, according to Detective Michael, and appeared like he understood everything that was going on. He also found that, regarding Detective Michael's testimony, he also said that the defendant had readily accompanied the police to the police station, that he was read his rights at the appropriate time, that he had indicated that he understood those rights, that he was 17 and just a few months shy of his 18th birthday at the time. He told the police when they asked him, "Are you impaired? Have you been drinking or have you been doing drugs?" And he told them at the time of the statement that he was not impaired. And again, he was giving appropriate responses. He said that there was no physical abuse, there was no verbal abuse employed by the police department to get him to talk. No promises were made, no threats were made, and the defendant never invoked his rights. In fact, he signed a waiver agreeing to give the statements that he gave.
And all of those observations, which could have been recorded, were not recorded. Is that right?
Well, they were recorded,
Well,
Justice Rosen.
what was recorded here? Because what
What
my
tape-
review of the record was that he was with the detectives for about 3.5 hours, and only about 45 minutes of that was recorded, and everything that happened pre-Miranda was not recorded.
Right.
Is that accurate?
And, no, well, no, that is not correct.
Okay, what's
What
correct?
typically happens is that Miranda is given at both times, both when they're off the record and then when they go back on record, they'll give it to them again.
Why is there anything off the record?
Well, I don't know that that was ever.
I mean, you recall the case
question?
we had prior, I think we released it about a year ago, or within the last year, where this court questioned that kind of conduct, where you have a huge period of time in which the interrogatee is being questioned, and then all of a sudden, there's about a 15-minute confession at the end of that includes Miranda.
Sure.
And
I
it
can
just
understand.
naturally leads to some suspicion of what's going
Right.
on there.
I can understand why people would be suspicious about that. And frankly, we have to deal with that when we're arguing to our juries because they have the same suspicion
Well,
about what
do
were
you
the
still
police
engage
doing.
in that practice?
But-
This happened, I give you some leeway here because this was 5.5 years ago, we're talking about 2008.
Well-
Are you still doing that?
First of all, I want to point out that there is no allegation in this case
I understand.
that anything improper happened during that time period.
I appreciate that's what my first question to counsel
Okay.
was.
And why did it happen in this case? I guess Detective Michael would have to be here to explain himself to you, but I can tell you that in my experience, it's because they talk about a whole lot of things. They talk about a lot of things, including prior criminal histories, things
I
that-
can't tell you how many jurisdictions record the entire time someone's in that room, and sometimes it's 3 or 4 hours of someone just sitting there.
right?
But it appears to be that you're one of the few that only record that time in which you believe is relevant when which a confession's made. And you clearly have the ability to record. So an objective, neutral person can look at that and not just rely on someone who has an interest in what's going on.
Right, and I can see where people can agree with that position. I can see where people can agree with the police department's position on this as well.
Well,
And
have you
I don't want to
directed,
debate.
have you notified the police department of our concerns regarding this based upon our last opinion?
Our police department is aware of your concerns of that.
Or
But
have
that's
they
not,
have they altered what they're doing now, or are they continuing in this
I
practice?
can't speak on their behalf. I don't know the answer to that question. But I'm really not here to debate the propriety of that practice today.
Well, I'm
Well,
concerned
I think
about
you're here to answer our questions.
I'm concerned about the practice. I think it just lends itself to all kinds of questions. And that's what we specifically warned you about in our prior case. And I'm just curious if that's still
Yeah.
the practice of
I ha-
Wyandotte County.
I personally prefer that the entire thing be videotaped as well. But I have been told that sometimes the video equipment is not available, sometimes it's not working, various other explanations
It
for it.
is 2014.
Well, I realize that, but just today here in our Supreme Court, the video technology is malfunctioning. And so, it
Oh, I
does
understand there could
happen.
be exceptions. I just wonder what the practice is.
Yeah.
I don't think you, in fairness, I don't think you argued the case in which we talked about this. It was one of your colleagues. And he told us then that there was a policy, the police department should do it that way.
Oh, I'm not so sure that there is a policy on that, and I wouldn't necessarily agree on that. Has it happened before? Yes. Has it happened lots
We've
of
seen
times
it
before?
several
Yes.
times. Yeah, we've seen it
Yes,
several
and it may just be a training thing, that's how they were trained to do it, and it just continues on. I've never seen a written policy. I've never had a commander say, this is exactly what our policy is. We have an oral understanding, or that this is how it has to be done. I also wanted to point out that, as Justice Biles, I think it was, caught on, that at the end of the Deno hearing, there was no other evidence that was presented. And I put in my brief that it appears that the defendant conceded that his statement was given voluntarily. Justice Biles seems to think that he actually did say that it was a voluntary statement. But the only complaint that they had at that time about admitting the statement was, well, he was only 17 and he was very afraid. And then later on, they seemed to continue on with that theme when they asked for reconsideration right before the trial was to begin. Well, I was only 17 and I had smoked some pot, and so I was particularly subject to intimidation by the detective. But there was no other evidence that was ever presented. This was
He
not.
wasn't allowed to testify when he asked to, and my problem with that is there was some indication that the court had said it already held a suppression hearing, and the defendant had an opportunity to testify then and raise any issues he had, and he didn't avail himself of that opportunity, and sort of indicating that, hey, it's too late to get one shot at this. And if that is the mindset, I'm concerned with that, because our view of 6404 is that you have to make a new objection at trial, even if you've had the Jackson v. Deno hearing. And the rationale for that is that new evidence may come up in the interim, and we need to allow the district court to decide it on the currently available evidence. And if the court is not going to allow the defense to get its additional evidence in there, there seems to be a little unfairness there.
Well, but in fairness to the state, Justice Johnson, it didn't happen in that way. If the defendant had said to Judge Burdett right before the trial when he raised this issue again, Judge, I have more evidence that I want to put on, before he made his ruling denying that motion to reconsider, then that, and then if the judge would have said, no, I'm not going to let you put on any evidence, that would be different. That's not what happened in this case. All that he did was proffer what he wanted the judge to consider. He didn't say, I want to testify, I want to put on other witnesses, I have other evidence that I want to put on in support to show you some changes or reasons why you should change your mind. And the proffer that he made to the court in both his written motion and then orally through his counsel at the hearing didn't add anything new. So I agree with you that, yeah, they should be allowed to present some new evidence.
Part of that proffer was that Gibson was under the influence such that he could not understand what was happening. And the court had the opinion of the officer on his observation. And why didn't due process allow the defendant to put his version of what happened? I consumed 1.5 pounds of marijuana. I didn't understand, and I mean, it seems like fundamental fairness would allow the defendant.
But that's
to
not
put on,
new. That's not a new issue. New evidence. That's not something that developed after the first ruling at the Deno hearing. He could have presented that at the time of the original Deno
Well,
hearing.
I understand that, but our case law says, well, things may be presented differently in trials, what we've said. We haven't required new evidence, like new trial kind of new evidence. We've just said it may come out in a different manner, that the judge will hear it in a different manner, and therefore we need to have the contemporaneous objection. And it seems to me that it's not too late for the defendant to give his version of events if we're having to ask for a reconsideration, which we require.
Okay.
Counsel, who requested the hearing, or who filed the motion that resulted in the Jackson v. Deno hearing being scheduled?
The state did. We filed a motion to admit the defendant's statement.
Any further questions of counsel? Any further presentation?
Thank you.
All right, thank you. Reserve 2 minutes.
Thank you, Judge. Just a couple things, and I think it was just touched on, and that's that at that Jackson v. Deno hearing, there was evidence that was presented. The defendant had his opportunity, and he chose not to use it. But I don't think that precludes him from coming back later, because new evidence can come up. And Michael's version, Detective Michael's version, was given, but the defendant never really got a chance to put on his version of those events and what he recalls about the interview itself. And I think that, you know, and there was some discussion earlier about, you know, the recorder being on, recorder not being off, and is that an issue? But it really is an issue here. You know, these are things that the judge needs to listen to. I mean, we're talking about a juvenile who we know was under the influence. Maybe not to what degree he was under the influence, because that information was never allowed to be presented. But I mean, all of these things should have been considered by the court when making the determination whether the statement was voluntary or not. And we just don't know if the court did consider these things because he just never said. And, you know, and I think it was also brought up, well, you know, what was the court's attitude at the time that the defendant tried to present his own testimony? And I think it was phrased like, well, did he just not want to hear it? And that's exactly what the defendant is saying here in his brief and what happened in court. The court had made up its mind at that point. I just don't want to hear it anymore. You want to testify? I don't want to hear it. No, ma'am, you're not going to put that on. You had your chance. He even says, I think specifically, you had your chance back in September. Last year, you had your chance. You didn't use it. So I'm not going to hear it now. And that is a problem. That's exactly why we're here today. That's exactly why we're arguing that this was wrong and this does need to be reversed. So unless the court has any further questions based on that, I close my argument.
Any more questions? Thank you, counsel. We thank you both for your arguments this morning. The court will take this matter under advisement.